Welcome back. This is 7.3, Who Authored and Who Owns Marvel's Characters. In this lesson, I'll discuss the authorship of Marvel's major characters. By the end of this lesson, you should have a good understanding of the ownership of Marvel's characters, how Jack Kirby's family was able to get a settlement from Marvel, and copyright issues regarding work for hire. The case of Jack Kirby. In September 2014, Marvel Comics settled a court case that it had brought against the heirs of Jack Kirby. Kirby's relatives had filed under a clause provided by the US Copyright Act of 1976 for the termination of the rights assigned to Marvel by Kirby for his various works published by them. Marvel argued that Kirby's heirs could not terminate because the work had not been assigned but in fact had been done as work for hire. Marvel won the case in the lower courts, but Kirby's heirs appealed the case to the Supreme Court, and the Supreme Court was due to hear the case when Marvel settled. As usual in these sort of cases, the terms of settlement are confidential. The case helps us see what some of the key issues are in owning superhero characters. Copyright. The origins of copyright lay in the UK Act, the Statutes of Anne from 1709. The basis of this act was providing recompense for socially useful acts, or as the Act put it, for the encouragement of learned men to compose and write useful books. Basically, as someone put time and effort into creating an artistic work, they needed to be able to earn an income from that work, or otherwise why would anybody spend the time creating such work? Because such work, as a result of this act, became a piece of property, and one of property's values is an ability to trade it, copyright quickly became something other than the protection of individuals and developed as a regime of property rights. Originally, the time that a work could be copyrighted for was limited, but since 1998, that time has been extended and is now the life of the author and 70 years. Before 1978, it was the life of the author and 28 years. One reason that the US Congress passed these acts is that some of the property protected by copyright, like superhero figures, was indeed more of a commercial piece of property and not so much the result of a single author's work. But in 1976, when the original extension occurred, an effort was made to grant some rights to those who had originally created the property. And so authors were given the right to terminate the assignment of rights to their work. Key point 1. Copyright can be assigned by authors who create work. Siegel and Shuster and Jack Kirby's heirs tried to reclaim those copyrights. Work for hire. The issue of work for hire is relatively simple. Comic book companies have said that various authors created the work as employees of the company or as work commissioned by them. In Jack Kirby's case, that is difficult for Marvel to prove since Kirby worked at home. And Kirby received no vacations or sick leave from Marvel. There are apparently no written records available to show on what basis work was created. In Siegel and Shuster's case, a judge found that Siegel and Shuster did indeed create the work with no input from DC. The reason that Siegel's daughter lost her case to recover the copyrights that had been assigned was that a judge later found that she had entered into a legally binding contract with DC before attempting to recover those rights. As a consequence, it mattered little that Siegel and Shuster had not created Superman as a work for hire. Key point 2. That Marvel settled with Kirby's heirs suggests that it is worried about its inability to produce documents showing that he worked for hire. By settling, they retain control of what have become billion-dollar characters. The issue of ownership and the ability to profit from it is rather fluid, or at least has not been fully tested under the law. Stan Lee. In the late 1990s, Stan Lee tried to reinvent himself as part of an internet media company that took his name. It was called Stan Lee Media. That company, with whom Lee is no longer associated, has launched several cases against Disney, who now own Marvel, claiming that Stan Lee assigned his copyright interests to Stan Lee Media. To date, the US courts have rejected all these attempts. Key point 3. Creation does not equal ownership, but likewise ownership of a copyrighted figure like a superhero does not equal ownership forever. This lesson has 3 key points. Go back over your notes and the video of the lesson to make sure you have noted these points. Next up, Lesson 7.4, Readers, Audiences, and Fans.